regarding Norwegian ambassador to Pakistan's appearance in Supreme Court of Pakistan. What's the update, whether it was violation of diplomatic norms, Vienna Convention, and if there is any further development, please do share with us. Thank you so much.
Regarding the Norwegian ambassadors, firstly, the matter rests. We issued a statement. The Norwegian ambassador was called to the Ministry of Foreign Affairs, and so this matter rests now. But on the broader principle of ambassadors' presence in court proceedings, I think in principle we can say that the presence or attendance of ambassadors in a court of law is not their right. uh, Ambassadors enjoy diplomatic immunity, and this comes with a certain responsibility. So, the presence of diplomats in a court, particularly if they meet or are greeted by a party to the conflict, party to the case, can be seen as influencing or seeking to influence a judgment. So, this is this can undermine the judicial process. And secondly, the fact that diplomats enjoy immunity, that is also a factor that warrants that the presence of ambassadors in a court proceeding, presence of diplomats in a court proceedings need to be regulated. So, in principle, diplomats wishing to attend a court proceeding anywhere in the country, they need uh, to approach the Ministry of Foreign Affairs for approval. This approval would be processed by the Ministry of Foreign Affairs. And I also believe that the diplomats wishing to attend a court may have to waive off their diplomatic privilege and immunity if they wish to make an appearance in the court. This matter is, as I said, is in principle. These are the principles that what I'm telling you. I'm not commenting on a particular case or on the case of the Norwegian ambassador, which I has already said it rests now. So please take my longer explanation not as a comment on that particular instance of Norwegian ambassador, but a description of the principles. Thank you.
I need your guidance that whenever any ambassador is appointed in any country like Islamabad, they are given certain do's and don'ts in shape of in writing, that they can go in certain areas and they can't go in certain areas. As per my information, please update me if there is a change. That there is no that ambassadors they used to attend the open court hearings. We have seen this in Panama investigations in Supreme Court of Pakistan. We have seen certain issues in during the Memogate Commission in Islamabad High Court, and there are many incidents. So have we changed those rules which you have just mentioned, and the ambassador's appearance in Supreme Court, which is an open court? How you can say that it's violation of their conduct, as at the same time when Norway has defended the stance of their ambassador?
Sir, as I said, the case of Norwegian ambassador's appearance in a court we have rested that matter. So we are, in response to your question, I can only talk of principles. So let keep Norwegian ambassador's incident out of this discussion, and let that disclaimer stand out as a heading of our discussion. You have talked of principle. The fact is that ambassadors, diplomats seeking to appear in a court have to seek permission of the Ministry of Foreign Affairs of Pakistan. I mean, this is very clear. In previous instances that you referred, they might have applied for the permission, and that permission may have been granted. I'm not aware of that. But what I'm now telling you, that and you also mentioned about the do's and don'ts. I don't think that ambassadors or diplomats are handed over we have a do's and don'ts list. I mean, this is part of the customary training of all diplomats across the world. That is why we have diplomatic training institutes, and these diplomatic training institutes have cooperation agreement with each other, and they sort of exchange the syllabi and teaching instructions. So this is part of the diplomatic syllabus about. But court appearances, I can tell you, are not automatic. It's not the right of a diplomat to just walk into a court and observe court proceeding and meet and greet one party or another. This has to be regulated. Because regulation is also essential, because diplomats have a privilege of diplomatic immunity. I'm not talking of any particular incident, but let's assume a situation where the court proceeding is going on. A diplomat becomes rowdy or abuses court, or his behavior is untoward, and then he or she tries to impede the progress. Can a court of law hold him for contempt? So this is not a straightforward. It's ambassadors, diplomats cannot walk into a court just like they walk into a grocery store. These two, the situation, the complexity of the situation, I'm sure you would appreciate. So this is where matters. So anybody wishing to uh, attend a court would have to come through the Ministry of Foreign Affairs, and probably we'll have to see how far his diplomatic immunity needs to be waived off in order to allow him to enter to appear before a court. This is principle. There's no new rule. I'm sure that it's always existed. Uh, it's always existed, and this is not a new rule. And I can tell you from my own experience in serving various capital, I can tell you that I have attended a court hearing in an important Supreme Court case in a country that I was posted. But that was at the explicit approval and part invitation from the Ministry of Foreign Affairs of that country, who wanted diplomats to view it as part of their, the judicial processes that country was undertaking. So this is very clear. And this is not a new rule. This is a customary diplomatic rule of engagement that has existed always. And if our diplomats are posted to a certain country and they wish to attend a court hearing, I'm sure they'll have to go through the host government's ministries of foreign affairs.